My mini lesson will be on the New York Times Company versus the United States court case that occurred in 1971. The case is also referred to as the Pentagon Papers case. What occurred is that the Nixon administration attempted to prevent the New York Times and Washington Post from publishing these papers that originally belonged to a classified Defense Department study on the history of the United States activities in Vietnam. The president argued that prior restraint was necessary to protect national security. In this case, defended the First Amendment right of freedom of the press against prior restraint by the government. The question before the court was whether the constitutional freedom of the press, which is guaranteed by the First Amendment, was not protected when the executive branch needs to maintain secrecy of information. In 1967, the Secretary of Defense, Robert McNamara, commissioned a secret government study on the United States' involvement in the Vietnam War. The Vietnam War began in 1965 and did not end until 1975. The war felt very prolonged and took many soldiers' lives. The study was completed the next year in 1968 and had volumes of classified information, which was all kept in the Pentagon. In early 1971, Daniel Ellsberg, someone who worked for RAND and had access to the Pentagon, had also worked on the secret government study. He had access to the papers and was shocked by the information he found. Because of these shocking discoveries, he decided to secretly make copies of over 7,000 pages of documents and pass them to reporters from the New York Times. The volumes exposed in government knowledge that the war would cost more lives than what the public was being told, that it was escalating even as the president had said the war was close to ending, and it also talked about illegal bombings in places such as Cambodia. This information would have angered many Americans if they knew what was actually occurring in Vietnam. It had endangered people's husbands, fathers, and sons, even though the war was escalating and not soon to end. On June 13, 1971, after several months of review, the New York Times finally began to publish these Pentagon papers. After the first articles were published about the United States' involvement in the Vietnam War, the Nixon administration immediately got a restraining order that tried to prevent the New York Times from publishing more of the papers. The Nixon administration argued that it put our national security at risk. He described it as a security breach. Nixon's Attorney General, Josh Mitchell, issued prior restraint, which is when the government prohibits the running of material that would be published or broadcasted on the grounds that it is harmful to the country. Basically, the Nixon administration tried to stop the presses before they could run with the information. This was the first time the government issued prior restraint, and it's considered a huge form of censorship. In response to the restraining order, Ellsberg also released the papers to the Washington Post. Additionally, 17 other newspapers also began publishing articles about these very controversial papers. The government wanted to issue another injunction towards the Washington Post, but they were not successful. The Nixon administration tried to prevent the New York Times and the Washington Post from publishing these classified papers. The government made an appeal, and along with the New York Times appeal, the case made it before the Supreme Court. And the Supreme Court agreed to hear the case shortly after, on June 26, 1971. The arguments before the Supreme Court were that the New York Times argued that Nixon's administration effort to prohibit running these papers was against the First Amendment. The New York Times was represented by Alexander M. Bickel, and the Nixon administration argued that the action of the New York Times went against the Espionage Act of 1917. The Nixon administration was represented by U.S. Solicitor General Erwin N. Griswold. Some background information on the Espionage Act of 1917 was that it was created during World War I to prohibit obtaining information, recording pictures, or copying descriptions of any information relating to the national defense with the purpose or the belief that the information acquired could be used to harm the United States or the advantage of any other foreign nation. At that time, any action that interfered with the U.S. Armed Forces, prosecution of the war effort, or to promote the success of the country's enemy was considered a crime. The Nixon administration deemed that obtaining the Pentagon Papers could harm U.S. relations with other nations or with their own people. The court then determined that they could not apply the Espionage Act to the New York Times. They realized that the intent of the Times and Washington Post was not to cause a country danger. Instead, it was to inform the country on what really occurred. They were trying to clear the understanding on what actually occurred in Vietnam. In a 6-3 decision, the court dissolved the Nixon administration order and allowed the Times to continue publishing the papers. Although there were many concurring opinions, the court agreed, and I quote, that only a free and unrestrained press can effectively expose deception in government. In revealing the workings of government that led to the Vietnam War, the newspapers nobly did what the founders hoped and trusted they would do. Another interesting thing about this case was that there was no majority opinion. 6 justices issued concurring statements. As I said, they all agreed there was no justification of prior restraint. Justice Black said the First Amendment gave the press freedom to fulfill their role in our democracy. The press's purpose is to serve the governed, not the governors. And Justice Douglas concurred that the First Amendment provides that Congress should never interfere with the freedom of speech or the press, which would leave no room for governmental restraint on the press. Another judge said that prior censorship would not be permissible in certain circumstances, and because the statements were so vague, the claims that it harmed national security in this case didn't justify prior restraint either. Another judge also argued that the legislation the government used to support this case, which is the Espionage Act of 1917, did not support the government's case. Justice Stewart and Justice Marshall said that the court shouldn't grant a restraining order without Congress's guidance. Along with the concurring justices, the dissenters were also very divided on the topic. Chief Justice Burger said the documents published by the Times were stolen and the newspaper should have reported theft. Justice Harlan and Justice Blackmun said the case was rushed because the newspaper wanted to publish the paper so quickly and the justices needed more time because of the serious issue of national security. The timeline of this case was very close. To give you an idea, the New York Times published the case on June 13th, 1971. The case was heard on June 26th of that year, and the court issued its opinions on June 30th. It was a very close timeline and not much time in between the actions. The impact of this case is that the court said that the government did not demonstrate or have proper reasoning for the issuing of an injunction of prior restraint. Additionally, it stated that under the First Amendment, the press must be left to publish news, whatever the source, without censorship, injunctions, or prior restraint, and that the keeping of military and diplomacy secrets at the expense of informing Americans on the actions of the government will never be justified. This was a very important decision that expanded our First Amendment right of the freedom of the press. It protects us from the government, and media outlets will be protected to always inform Americans on what is actually going on behind the scenes. It was a huge victory for the newspaper and free press advocates.